Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. And today we are learning again from the Kyle Rittenhouse trial, day 8. Kyle Rittenhouse himself takes the stand. Yes, this was forecast by the defense during the opening arguments, and I and pretty much everyone else thought, surely, no, this is not going to happen. Surely they must have just misspoken, or slipped up, or somehow gotten confused. But no, unfortunately, that was not the reality of the situation. The defense actually meant it. And apparently the defense lawyers themselves counseled this exact result, because they said that when during the whole colloquy about, are you sure you know what you're doing? Let me advise you of your basic rights. Which, by the way, that part is perfectly normal. The judges phrased it a little differently, and his was a little bit more informal. The judges was a little bit more informal than I'm used to in terms of this, in terms of going through, making sure everything is covered. But it covered the basics. So the colloquy of, do you know your basic rights? Do you know you don't have to testify? Do you know you can testify? Do you know that they can ask you anything they want? And so forth and so on. And Kyle Rittenhouse is over there like, yep, I understand. And it's like, is there a reason I shouldn't accept this? And the defense lawyers said, no, because we thought this was a good plan. Okay, I don't know why that you would do that. You have everything you need from everyone else. You can't get anything new from Kyle, nor did you get anything new from Kyle. There was a suggestion in the chat today, in Nick's chat, that this is the normal in Wisconsin. That it's just normal for defense lawyers in Wisconsin to call their clients to the stand in self-defense cases. I have a very hard time believing that. I have a very hard time believing that Wisconsin is substantially deviant from the rest of the country, and like the entire Wisconsin defense bar is apparently of the opinion that this is a good plan, whereas the rest of the bar is of the opinion this is a bad plan. I don't think that's a thing. I don't think that's a thing that's happening. So I can't really comment intelligently about why someone would counsel this result. It's all downside. It's all downside. So Kyle took the stand, and he did fairly well for himself, all things considered. No thanks whatsoever to either side of this equation. Both sides were incompetent in their own different way of incompetence. And they were both bad. First of all, let's talk about why the prosecution was bad. The prosecution was bad in cross-examining Kyle because apparently they forgot that in cross-examination they're allowed to ask leading questions. It is significantly discouraged to ask open-ended questions on cross. You can, there's nothing stopping you from doing it, but I've never heard this recommended ever in any trial advocacy course I've ever taken or any book I've ever read on the subject. That some people will go to the utter end and basically you should never ask an open-ended question, which is probably closer to being true than the alternative statement. The thing is, the wonderful thing about cross-examination is you literally get to put words in the mouth of the person you're cross-examining, because you can ask them questions like, that's when you decided to shoot at him, correct? Or that's when you decided to kill him, correct? You can put the words in his mouth, and maybe they'll correct you, or maybe they won't. But the whole thing about cross-examination is you get to ask questions that provide the answer. See, when the prosecution was doing this throughout all their directs, the prosecution was feeding their witnesses the answers constantly during direct. You can't do that during direct. That's called a leading question. Or during direct, you have to ask open-ended questions. These questions would be like, you were at the car source on November the 24th at 4 p.m., right? Why were you there? Who was there with you? What were you doing? Were you armed? What kind of arms were there? What happened next? Did you see a dumpster fire? Okay, when you saw it, how did you respond to it? And so forth and so on. The questions are meant to elicit from the defendant, or the witness, whoever it is, meant to elicit the story. During direct examination, the witness is the star. The job of the lawyer is to get the hell out of the way to the maximum extent possible. The witness is the star. They're the ones providing all the information. You're just there to help signpost them through the story and hit the points and provide the and what happened next, and what happened next, and what happened next in other versions of those words so it doesn't get unduly repetitive. But you're there to provide the points of the story that they are then going to elaborate on, and everything comes from their mouth. The ideal is the lawyer disappears and the witness is all that's left, right? That's the ideal. Indirect. Now, during the prosecution's witnesses, they weren't doing that. They were outright feeding them the answer. That's something you do on cross, right? In cross-examination, it's the attorney that's the star, not the witness, right? So the attorney is the one who's front and forward and providing everything and getting the other guy to hopefully agree to everything you're saying or not fight back or so forth. But you're feeding them the answers. That's what cross-examination is. But apparently the prosecutor has directly flipped in their mind what direct testimony looks like and what cross-examination testimony looks like. During the prosecution's direct, they were crossing. And during the cross, they're directing. This is weird. This is very, very strange. The prosecution asked some version of why to Kyle Rittenhouse many times. Why is not a question you ask on cross. You ask all the leading questions ever. You went to the car source, right? And you had a gun, correct? And that's when you saw Rosenbaum, right? And that's when you formed the intent to kill, blah, blah, blah. You know, obviously not that extreme. You played a little bit more subtly than that, but you get the point. So the prosecution, I don't know what the exact balance was, but in my opinion, it was more direct than cross. There were much more open-ended, free-form questions of, please just tell us your story, which is a bizarre thing to do on cross. I mean, crossing indirect, I guess, makes sense if the other side's not going to object. So if you can get away with crossing in your own directs and the other side's not going to object, then yeah, I guess so, because why not feed them? Although I still think that's not ideal. Ideally, you want them to tell the story, but if they're going to let you get away with it, you can. But why you would not want to lead them and control the story and get them to bow to your storytelling is beyond me. So the prosecution strategy was bizarre. The other thing that was bizarre, and this is also a point that I'll come back to on the defense, but asking the same question so many different ways that it was just off-putting to the jury. There was tell about the jury failing to pay attention, stopping taking notes, leaning back in their chair, generally not paying attention, and so forth and so on. The prosecution just came off as very badgering, and he came away with nitpicky and stuff. It just didn't work. And apparently the prosecution is completely unable to read the room, and I'm not even sure 100% how that's possible, because surely he can see whether or not the jury is engaged. They're like right over there. He just has to kind of look vaguely in their direction once in a while to see if they're engaged or not, and apparently did not, or is unable to read what's going on. So all those good things. What was I saying before I was distracted by the chat? I lost my train of thought. I shouldn't have done that because I lost my train of thought. But it was just weird how much they were badgering, how much they were really just nitpicking and trying to do things that was distasteful. it felt very off to me. It felt just very unwelcomed. I just, the prosecution didn't seem to have any charisma at all, which is just a real weird thing on every possible level. It was just weird. Now, defense lawyer themselves also was inexcusably asleep at the switch. The prosecution even made a point one time of pointing out how Kyle was looking at his own defense attorneys, and which I'm not sure why the prosecution made a point of mentioning that, but Kyle is looking at his defense attorneys with eyes of please save me, please save me. Either his defense lawyers again aren't able to tell that, or don't care, or whatever, but it was bizarre that the defense was just not objecting constantly. The asked and answered objection could have been raised, I don't even know how many times. Everything was asked and answered over and over again, so many times. You only get to ask the question really once. And he was asking the questions a dozen times, more than that. And Kyle, to his credit, was standing his own, but still, asked and answered, and just badgering. It was just distasteful. But and not only that, but the defense didn't even raise any tactical objections. They didn't raise any objections just to break up his flow, which is bizarre because they had plenty of objections to work with, but they apparently had no problem for the vast majority of it just letting him be grilled relentlessly by the prosecutor and never objecting to anything. It was driving me and the panel kind of crazy. It was suggested by Alita, who I think picked it up from Twitter, that maybe the reason was because the defense attorney was looking at the jury and realizing that the prosecution was coming off really badly. And again, it is going to this idea of never interrupt your enemy when they're making a mistake. So that was what was really going on. So I asked Robert Barnes on stream about that. It's like, do you think that's a thing? And he said, no, that's not a thing, not with this defense lawyer. And I'm like, okay, yeah, that's kind of what I thought. I just figured I'd ask since you were there. That was not the read I was getting, and it's not the read Robert was getting, and he was there for a lot of it and knows these people. So I'm certainly willing to bend to the confirmation bias. I'm being told it is what I think it is, but it was just really, really weird that this defense lawyer was not backing Kyle, even when Kyle was basically screaming for it with his own eyes. It was truly a weird thing to behold. $10 from Silverfish says, how do you think this will play out in the court of public opinion once the trial's done? We're already seeing mainstream media downplaying the PTSD attack and focusing on the ringtone. Yeah, that was kind of weird. That was definitely a weird thing that happened too. $5 from Josh Parson. $5 from Jonathan Rengrath. Right of self-defense shall never be denied. True that. $5 from Michael Teenan. Outside call, the only stars in this trial are the judge, Agent 47, and Grambo. Cute. Is there any other chats? $5 from John O'Brien. Kyle was the best advocate in the room. Yeah, we'll get there. Binger should face discipline, and Richards needs to be checked for a pulse. I don't know that. Well, Binger needs to be disciplined for other reasons, and we'll get there eventually. But yeah, $4.99 from Stephen Light. Thanks on Uncivil Law. Great coverage. Thank you. $15 from Michael Tynan. Just thank. That's all. I appreciate it very much. $2 from Yellow Jacket. Thanks for all you do. Appreciate all the super chats. And $5 from Scott Minikim. Can you explain what the prosecutors required to show to prevent the case from being dismissed with prejudice? We'll get there. We'll get there once I get through the testimony in proper. But yeah, the fact that he was not there, and Kyle was doing very, very well. Now, obviously, someone had prepped him, so thank God for that. I assume it was they assume it was a secondary defense lawyer who prepped him, but he really avoided some major fall points. You know, it's like saying you were trying to kill him. No, it's just trying to stop the threat. It's like, that's the language you want. That's perfect. And he made sure to say that. You know, he didn't want to kill anyone. He wasn't trying to kill anyone. He was doing a very good job resisting the prosecutor, who was asking the same question over and over. And he didn't get angry. He didn't fluster. He didn't change his story. He just resaid what he said in slightly different language. And he was doing a really good job. No thanks to his lawyers at the moment, but he was doing fine. I mean, at any point, he could have slipped up and said something horrible. You know, the fact that the defense lawyer was just letting this go on and on was just truly amazing, that it was going on and on. But Kyle did fine. I didn't catch him saying anything that was a major fail. You know, he didn't say anything that was a major fail. And that isn't to say that he didn't say anything that was incriminating against him. I promise you that right now someone is going through those transcripts with a fine-tooth comb. And Kyle said some things that will be able to be used in some way. There's nothing major that popped its head up, but it wouldn't surprise me at all if the prosecution brings something that Kyle said to the jury's attention when they're deliberating. I don't know what that is, because I'm not going to go through the transcripts in a fine-tooth comb, but someone's doing that somewhere to figure out what those moments are. Nestor says, can you complain to the judge about getting asked the same question over and over? Yes, it's literally called asked and answered. It's an objection. Yeah, you can't be asked the same question more than once. So the objection is asked and answered. It's an objection. Yes, you can complain. Why was his defense lawyers not doing this remains the ever-present question. It doesn't make any sense. Oh yeah, the driving without a license. You drove without a license. Okay, so now that we've talked about the bizarro prosecution in terms about the way they ask questions. We talked about a sleep at the switch defense, and we've talked about Kyle doing a very, very good job for a very long time, keeping everything going and being by far and away a much better advocate for himself than, to be quite honest, we would even expect from an adult. So his ability to manage this was notable. I don't think we really gained anything out of it. So I don't think there was any upside, but we didn't see any massive downside, so I guess that's a win. Anyway, but we would be remiss if we didn't talk about the other major errors from the prosecution. Errors so bad that it might get the case thrown out. So there were two things of note that occurred today by the prosecution, both of which were pretty bad. The first of which is the prosecution twice made a comment about the fact that Kyle Rittenhouse had not opened his mouth prior to trial time, right? He twice made a comment that Kyle, had the opportunity to speak, and he didn't speak. This is a no-no. As the judge made a point of, as the judge made a point of noting, this is bad. For 50 years, maybe a little bit more than that, but the U.S. Supreme Court long ago said you can't comment on the fact that a defendant doesn't speak, like ever. Pre-trial, during trial, you can't comment on it. You can't comment on the fact, well, he had these opportunities to speak and he never opened his mouth till today. This is the first time we're hearing from him. That's just a full stop. Full stop. The judge called it a gross or grave constitutional violation. It's bad. As will surprise literally no one who has a brain. The defendant enjoys an absolute right to remain silent, which is absolute. So you can't disparage it. You can't comment on it. You can't hint at it. You can't make allusions to it if you're the prosecution. That's a no-no. That the defendant didn't speak prior to this, no. And he did it twice. He was warned, And then he was severely chastised by the judge, as he should be, because as Emily D. Baker was pointing out, not that I've ever been to prosecutor school, but apparently when she went to prosecutor school, this is something they drilled into her pretty early. I'm sure they did. This is misconduct. And then it becomes a question of whether it's deliberate or not, for whether or not there should be a dismissal with prejudice. So there's a whole thing there. And then the second thing is, which I don't know if it's worse or not, but it's debatable. There's this whole issue about whether or not the prosecution would be able to ask Kyle about some prior incident wherein he said, in regards to CVS looters or something, he said something along the lines of, I wish I had a gun so I could shoot them, right? So he had said this about some prior incident. Now the judge had ruled this was inadmissible, okay? And the prosecution made a point of asking about it while Kyle was being asked to stand, right? He made a point of asking about it. And the judge said, no, I have no reason to change my rulings. All my rulings are still in place. So what did the prosecution do? The prosecution asked about it. It's like, yeah, you made these statements about this thing in the past. And so the defense throws an absolute hissy fit, as they should. It's worse. I'm not sure which is worse. One is a gross, grave constitutional violation, but the other one you had just been reminded about that morning by the judge, and you were directly defying the judge's order. So they're both pretty bad. So the whole thing is just completely weird. So in answer to Scott Mikahim's question, can you explain that the prosecution is required to show the case, prevent the case from being dismissed? Basically, he has to show, or it's actually the other way around because the defendant has to prove it. But the defense has to show, essentially in so many words, that the prosecution did this deliberately, intentionally, to provoke a mistrial. Right? So if he just slipped up, if he just got carried away, right, it's not enough to provoke a mistrial with prejudice. But if the defense can show they did it deliberately, intentionally, for the purpose of provoking a mistrial, you're there. And the judge's comments today would lead you to think you're there, because they had this whole exchange about, well, I was doing it in good faith. I had these good faith reasons. The judge just says flat out, I don't believe you. Right? So that's a question of fact. Did the and in this context, this is a question of fact for the judge, because we're not asking about the defendant for a jury trial, right? We're not asking that question. We're asking, did the prosecution do it deliberately? Okay, that's a question for the judge, where the judge is a fact finder now. So the prosecution gets up there with, oh, I didn't do it deliberately. I have this good faith basis. I had good faith reasons. And judge just says, nah, I don't believe you. That's what the judge can do, right? That's a question of fact. So the judge apparently has reached the conclusion that this is bad faith. This is being done, with bad reasons. So he did it intentionally, presumably for the purposes of provoking a mistrial. He took the motion under advisement. And your guess is as good as mine as to whether the judge will do anything about it now, or whether the defense will wait to wrap it in. So will the defense make a formal motion in writing tomorrow, or will they wait until the conclusion of their case and they'll put it in as part of a series of motions? So they'll wait till their case is concluded, and then they'll put in a motion to dismiss for failure to state a case, motion to dismiss for prosecutorial misconduct, directed verdict, so forth and so on. So whether or not they'll resolve this tomorrow and how the judge will rule on it anyway, your guess is as good as mine. But it seems like, from my perspective, the judge has already made the ruling for the prerequisites. Did he do it deliberately? Did he do it intentionally for the purposes of provoking a mistrial to the prejudice of the defendant? Judge kind of already said yes. So it makes you think, what else is there to do? But I guess he wants to sleep on it, which, fair enough. Fair enough. You don't want to act precipitously, particularly when, dismissal with prejudice means game over. So, you don't want to act precipitously. You want to think it over. Respect. I can respect that. Even if the judge has already said, I basically found it. Respect. The judge wants to take a little while to reflect on it. I understand. I get this. So whether or not the judge will do anything about it, who knows? But that's one of the questions. Did the prosecution do it deliberately? And with the prejudice to the defense of, you had this opportunity to speak and you didn't. They're pretty bad. So the defiance of the order, the thing, it's pretty bad. So I think if I were a betting man, I don't know that the judge is going to do anything about tomorrow. But if the defense, and it surprised me the defense didn't move for a motion at the end of the prosecution's case. So that surprised me. So I don't know why I'm assuming the defense is going to make motions at the end of their case. So why would I be assuming the defense is going to ask for a directed verdict or a motion to dismiss for failure to state a claim or failure to rebut the affirmative defense or prosecutorial misconduct? Why would I make these assumptions, particularly with this defense lawyer who appears to be asleep at the switch? I don't know. So maybe they won't do any of those things and this entire conversation is pointless. Mono Labby says, how much would the gun charge been mitigated if Kyle done an 8%? Since legal for him to buy and build his own AR at age 17? I don't know the law that well, so I won't comment on that particular aspect. $4.99 from Hen House Bath. I've really enjoyed your coverage of this trial. Thank you. John O'Brien, attorney here, New York and Florida. I've seen discipline for less. Truth. BM for $4.99. The people who are so deathly afraid of AR-15s are incredibly annoying. I can never stand to read comments in case there's one involved. That was a nice little thing from the prosecution too. It's like he just had a small, insignificant pistol, and you had a big bad AR. So he wasn't really a threat to you with this small, insignificant pistol. So yeah, all those good things. All those good things. Let me log on to Discord and see what questions you have for me. Yes, I'd like you to show me. That would be great, to the person who asked me in chat. Let's take a look. $10 from Drew, or 10 Australian dollars. My battery is dead as Rosenbaum. Cute. Very, very cute. Let's take a look at your chat questions that you've been asking. Have you seen defense or prosecution worse than these? Yeah, I've seen defense lawyers who are worse. I'm not sure I can remember a prosecutor who's been worse, but I've seen some really bad defense attorneys, so yeah, I'm not sure about the prosecution though. This is pretty bad. Joe's Med said it wasn't an unmitigated disaster for the defense. This is true. It wasn't. So we didn't have to completely blackpill everyone again, which was nice. But how the jury responded to that, what they thought about him crying, whether or not he was faking it or whatever they were thinking, I just don't know there's any benefit. But it was an unmitigated disaster. I can't point to a specific thing Kyle said and said, well, this is the thing that will, damn him. I'm sure there was something that the prosecution will find when they go through the transcripts, but there wasn't anything that popped out to me. Evil Lash said, were Kyle's lawyers even in the room when he's getting cross-examined? I even put in the private chat in the Streamlabs app, so it's just for the attorneys, but I even put a comment in there. It's like, was there a motion during the middle of the cross-examination for Kyle to proceed pro se? Because where are his attorneys at? Was there a motion that I missed in the middle of the cross? Internet commentator says, can you explain the differences between cross and direct and the relationship to leading, yes, no, and open questions? Direct, you ask open questions because you want the witness to be the star. You ask open questions because you want them to testify as to what they saw. In cross, you ask close-ended questions because you want to trap them inside your frame. So you provide them all the answers and you get them to say what you want. So that's the relationship. Propter Hawk says, I think Binger should be disbarred. This hack is going to be a future judge. I'm not sure about after this one, but yeah. Joe's Med said, Uncivil laws, funny on cross. What was the urgency? I'm the fire. Right? I also like this whole line that presumed that people don't have a right to just go out themselves and put out fires. This was strange. It's like, normally, I mean, the idea he's ultimately getting or trying to get to, and never really quite got there, is that people don't have the right to act as their own police. But the way he got there was very clumsy, and he never really got there. It's like, you saw a fire. Normally people call 911. Why didn't you call 911? And Kyle's over here like, well, I didn't think they were going to be very responsive given what I seen. Yeah, but you could have called 911 and you didn't. Who are you to go out into the streets and put out the fires? What? Ben says, can the state sue Binger for malpractice? I'd never seen that happen before. I don't know that it's possible, but that's hilarious. Probably not, because he does have absolute immunity. So, but I've never known, but it's the state themselves suing him. So would absolute immunity apply? I honestly don't know. I'm not sure if that's ever happened before, with the state themselves trying to go after their own prosecutor for malpractice. I'm not sure if that's a thing. I'm not sure if that's possible, but it's kind of funny. Propter Hawk says, could Binger be charged with contempt? Is that a real thing or misused? Like people write me repeat. He could be charged with contempt for failure to obey the court's order, but it's worse than that. It's worse than that. It's that he might lose the case altogether. But yeah, contempt for failure to obey the court's order. Yeah. $5 from Crash Mondo. How about the line that Gage was not a threat because he didn't shoot at 10 or 15 feet? He waited until he was point blank. Yeah, this I don't understand. If he really wanted to shoot at you, he could have shot at you from 21 feet away in the dark with lots of other people moving around. Yeah. And he has a Glock 27, which is a small pistol. I have a Glock 26 and 9mm. I used to have a Glock 27 and 40 cal, so I fought with it. I fired a 27. It's a snappy little thing because it's a very small gun. It's a very small frame gun, and a 40 has a lot of oomph. So yeah, when you fire, it's not exactly, you can fire it accurately, if you have both hands and you get into a proper stance. But even then, at dark with people in between, I wouldn't necessarily want to try it. So the fact that he was getting closer, but he wasn't a threat. Yeah. John O'Brien says, like the entire history of fire brigades, right? It's like, yeah, this whole thing is really, really weird. It's weird on levels, man. It doesn't make any sense. There's 1,700 of you currently watching, by the way. That is a really good number for my channel. And I just want to say thank you to the 1,700 of you who are currently watching. If I might be so bold as to ask you, if you're not subscribed already, to please hit the subscribe button. I do lots of law on this channel. Lots of different laws. So much stuff competing for my attention. I released a story today regarding the Second Amendment in Missouri. I'm going to release part 2 tomorrow. I've got lots of other content coming along, and I try to find stuff that I think you guys are going to find interesting, or I think is interesting. There's over 1,000 videos of stuff on my channel, so I think you find a lot of value in it somewhere. So for the 1,700 of you who are currently watching, if you'd be so kind as to subscribe, I would really appreciate it. And thank you to all the people who have been subscribing lately, because I think I've gained something like 1,500 subscribers in the last week. So that's been really awesome. Thank you. Blue Hero Hoist says, I'm still confused why defense didn't redirect after prosecution was done. Also, defense did not acknowledge Kyle. A lot of what happened today confuses me. It doesn't conform to what I know as trial practice. I did take trial advocacy, and I got basically the equivalent of a minor in law school on litigation. It's called a certificate, but because it's not really formally a minor, but it's effectively the same thing. I did mock trial, moot court, and trial advocacy and all that shit too. My day-to-day job is transactional. I don't go to court. I have on very rare occasion, mostly as a, what would be the word for it? Pro bono. So I did some pro bono cases, not in patent law, of course, but I did some pro bono cases to, try to give back and stuff like that. So I have a very little amount of trial experience and only one criminal case, but that doesn't really count because it got dismissed to speeding, so it doesn't matter. Anyways, but even I know that this is just bad lawyering. I'm looking at this and I'm like, I remember doing moot court. I remember doing mock trial. I remember prepping. I'm like, I think I could do better than this. It's been a while since I've done it, but I remember how to do it, and I think I could do better than a lot of this. For example, I do know the word objection. I played Phoenix Wright. Ace Attorney. So I learned the word objection. Yeah. Silverfish 606 says, so how do you see this playing out in the court of public opinion once this is done? Also, congrats on the lawyers getting new subs. I don't know. I assume that the public at large is not going to have any different opinion than he started, because the public at large is not watching this trial. So they're going to be exactly where they were when they started this thing. Scott McMeem says, is it possible the whole prosecution is politically motivated? Yes. I think it's a pretty strong possibility that prosecution is politically motivated. I think so, yes. Gage didn't shoot from 15 feet away because he's going for a cheap shot to the head. Yeah, but he never shot you in the head, did he? It's like, this whole thing is just really, really weird. It's like, okay, this is fun. And congrats to Nick Rikita for hitting 220,000 subs. So he gained another 10% of his entire channel since yesterday. So this has been baller for him too. Yeah, Uncivil Law, Gage, he didn't shoot you, did Kyle in the head? Yes, because I shot him before he's able. Yeah, really. The judge is a drunkard? No, I disagree. The judge has been fantastic. I definitely disagree with the judge's rulings. But I disagree very much he's a drunkard. I think he's a fine judge. He's a great judge. Connor asks, 2L at Washington U. When we discussed this case in torts last year, my professor asked why I thought an active shooter had self-defense claims. What a sad state of affair in local schools. Well, if it's truly an active shooter, he probably doesn't have self-defense claims, because the term active shooter implies the malevolent intent, which would necessarily negate the self-defense claims. But I'm sure, the way you meant it was more on point. Michael Tynan, so you think some jurors might be so anti-2A they'll never acquit? Could be. I mean, your guess is as good as mine. John O'Brien says the Missouri case is really interesting. Article 1, Section 23, it's interesting comparison to 2A. Some ways better. Everyone check out the video. I appreciate that very much. I appreciate it very much. And nice to see you, Stephanie, as always. So let's see what we've got. Adrian said he was trying to impress the jury via nostalgia. I didn't really get that personally, but okay. Someone else had made that same comment as well. So you're not the only one who made this nostalgia idea. I just didn't really get that from the prosecution, so I didn't see it. But you're not the only one who did, so I guess that goes one way to show that two people looking at the same thing can see different things. I didn't really see the nostalgia thing. Someone else did, though, so yeah, maybe there's something there. Danielle said the ADAs generally come across as weirdo bullies. Yeah, they come off as so unlikable and so smarmy. It's really, really weird. It's really weird. Internet commentators, so how do you deal with opposing counsel on cross if you're on the witness stand? You don't. Yeah, you don't. That's what lawyers are for. If you're on the witness stand, you answer the questions. You answer the questions. That's what you're supposed to do. Your lawyers are the ones who object. So you as a witness can't object. unless you are your own lawyer. So if you're going pro se, then yeah. But otherwise, you can't object. That's what the lawyers are for. So all Kyle could do is look desperately at his side for hope and help that never came. $2 from James says, will the jury get self-defense instructions? Yes, they will. And they are working on rewriting some of the instructions tonight, as I understand them. Joseph says, was it a ploy to make Binger look like a total horse's ass? By the defense? That's the most charitable read. The most charitable read is that the defense was doing this deliberately because they just wanted him to look like a horse's ass, which is why I asked Robert Barnes, who was part of Kyle's team for a while and therefore is in a better position to know these people than me, whether or not he thought that was going on. And Robert said no. So yeah, I didn't think that's what's going on, but I made a point of asking Robert about it on the stream because I wanted to double check my own thinking, and he agreed with me. Would Binger's performance in court today constitute prosecutorial misconduct? Quite possibly. Yeah, that's part of the issue still to be decided. The motion to dismiss with prejudice is still pending because Binger seems to have done prosecutorial misconduct. It seems to me he did some things deliberately, intentionally, to provoke a mistrial, and you can't do that. So, and it seems like the judge thought so too. Azrael says, the tube is shadowing hard today. Yeah, they might be shadowing hard, but I'm still getting 2,000 people watching me concurrent, which is pretty awesome. So even all the shadowing in the world isn't stopping the Uncivil Law Army from being heard. All right. Aaron Commentator says, are you allowed to say the prosecutor, can you stop asking the same stupid question? No, as the witness, you can't. That's what the lawyers are for. And where are the lawyers? Azarov says, the prosecutor's strategy of skirt shaming was unbelievably disrespectful. Truth. Yeah, didn't you have it coming because you were wearing that outfit? Some of the questions were definitely of that style. So you're not wrong to make a analogy. How good the analogy is depends on a lot on your perspective, but there's definitely some of the same underlying theory there. Joe Smed said the judge said it was bad faith on the prosecutor's fault. They sure did. The judge sure did. The judge did say it's bad faith. I don't believe you. So given that, you would think the next logical thing to do is dismiss, because it seems like you've made all the predicate findings to dismiss with prejudice. Okay, hold on. I need to fix something. Hold on. Talk amongst yourselves. Someone asked me to put on, Stephanie asked me to put on slow mode, so I need to go into settings and do that. So give me a second. All right, now how do I change that? Okay, I can go here and go here. All right, I'll change it to subscriber only. I'll set a minimum subscriber time of any duration. And I'll set a slow mode to, let's try 30 seconds and see how that goes. Save. Great. Oh, did I hit 30K? Booyah. Booyah. Well, congrats to me. Congrats to me and the Uncivil Law Army for passing 30K in subscribers. That's a wonderful accomplishment. And it is because of your guys' support and Stephanie's support and the other moderators who are helping support and the people who are promoting me and the other channels and the collabs and all the things. You know, it's because of your guys and your guys' effort that this channel has grown and hit 30K. It's a major accomplishment. I'm very, very happy, and I'm looking forward to seeing what else we can do. You know, I did have a goal of 30K by the end of the year, so apparently I passed that one massively. Oh yes, and I have to make a pinned comment. You're right, I did forget about that. But yeah, I really, really appreciate everything, and I'm also going to make a pinned comment. So just respectful. Let me just find Stephanie's comment and pin that, so I don't have to rewrite it. Hold on. Where is it? I can't find it. I can't find it to pin it. There it goes. There, I can pin that. Great, thanks. Where was I? John O'Brien said, pretty sure, yeah. Someone said 30K subs and now you can finally retire. I really, really appreciate that. Thank you. $2 from John O'Brien. Pretty sure it was my super chat. Congrats. 1999 from Mithrin Emrys. Hi, Kurt. I know you sometimes get crap for it, but I love it when you take a devil's advocate position. It's what separates your channel from others. You analyze both sides equally, even when you disagree, keeping you. Yeah, that was a great little moment today in Nick's channel. That was a great little moment today in Nick's channel, and lets me know that some people somehow don't understand when I'm doing this, because I started getting so much hate all of a sudden. So Nick Rikita asked us at the end. He asked us at the end. It's like, can you find? Is there basically, in so many words, it's like, can you find any way that this is not self-defense? And so Alita and I started thinking about it. Right? It's like, okay, let me think about it and let me get back to you. And so Alita and I just start thinking about it as Nick is reading some other questions. And so like 2 or 3 questions later, I pop back up with, okay, I think I have an answer to your earlier question. And so then I started laying it out. And the chat and Nick's comment, they're so hostile to me. They're starting making names of me and all the rest of it. And I'm just have to say, and then I saw it in the chat where people were doing this. I'm like, guys, you do understand that I was responding to Nick's comment. He specifically asked me, is there any way for this not to be self-defense? So I was answering his question by trying to make this work. I don't necessarily believe in it. I'm just answering the question, trying to like, well, how does this work? I was like, well, if you assume that Kyle didn't hear the comment, or he forgot the comment, or he didn't recognize the guy, then he's just being chased, and it's a non-lethal force, and Kyle's pointing the gun for us, so that's the first bad act. So then Kyle's in the wrong, and he loses his self-defense, so maybe all that. And the chat was not happy, and they started calling me names. It was annoying. It was annoying. It's like, I'm just answering the question. Ender Fail says, here's to another 30K. Thank you very much. Man. Yeah, that uncivil flaw. That's fun. Becky says, did Kyle only turn and point the gun after the gun shoot and or the bag throw? Yeah. I think it was also a mistake. It was a mistake. Kyle did make a mistake. Although it didn't hurt him that much, he was able to recover from it. But Kyle did make a mistake in saying that he didn't think the gunshot came from Rosenbaum. That was a mistake. He didn't need to say that, and it was an error. It's like, it would be more logical. Well, I think the chances of a not guilty verdict, I think a hung jury or not guilty verdict, well, for the top counts is still really high. For the reckless endangerment, they're looking at new jury instructions as I understand them. So given the jury instructions right now, I don't know, because the jury instructions are a mess. The way they're written right now, it's so confusing. So I think you would have to reasonably predict, given the jury instructions right now, you'd have to and assuming the jury is following the law. So you could come up with a situation where the jury gets so pissed they just go not guilty across the board. But assuming that they're actually looking at each issue separately like they're supposed to, then I think you'd have to predict guilty for the reckless endangerment because of how the charge is being written. And likewise, you'd have to say guilty for the possession charge because of the way the jury is being charged. I think they're being charged incorrectly, but given the way the charge is being given, you would have to find him guilty if you're following the law. So they are probably following him guilty of the reckless endangerment. They definitely should find him guilty, again, given the jury instructions, for the possession. But for the murder, attempted murder, I think you're still looking at 95% for acquittal or a hung jury of some kind. And of course, even if you get a hung jury, there's nothing stopping the judge from saying, how about not a hung jury? How about not guilty? So that's also a thing too. €10 from Jack Bauer. It's pretty absurd the prosecutor's office is now visibly acting out the kind of injustice behavior that apparently brought these rioters in the street in the first place. True that, my friend. True that. $9 from Josh G. How can Kyle be consistently berated as a child by the same guy who's charging him as an adult? And why did Richards whisper advice to the prosecutor accusing Richards of murder? I doubt he was whispering advice. He was whispering, like giving the prosecutor a heads up or something. They talk amongst themselves because they need to give each other a heads up sometimes. Like, I'm about to present this exhibit. I'm about to present this exhibit, so get ready for that. Or I'm going to ask this question just to, there's reasons you have to give the other lawyer heads up. So they're communicating about stuff like that, I'm pretty sure. And there's nothing wrong with that. In fact, in many cases, it's required. $5 from Joanne Smith. The process is the punishment. Is the judge furthering this injustice by not immediately declaring a mistrial with prejudice? Kyle's legally innocent. I don't think so. I think judges have different philosophies on this issue. Judges, I think for fairly good reasons, are hesitant to insert themselves, particularly in the middle of the process. The judge even said as much about not being a constant police person or confident. He just takes the objections as they had. This has to deal with the expert with the pinching and zooming, because the defense had objections like, and the prosecution said, well, we offered lots of evidence like that before. And the judge simply said, which is absolutely the right answer, well, I'm not here to be a policeman. I'm just here to rule on the objections you give. Apparently you guys were totally cool with it, so I'm not going to interfere. But now they've raised an objection, so I'm going to give a ruling on it. So, yeah, I don't think the judge is doing anything wrong. He's just following a fairly common judicial philosophy of restraint. Silverfish says people need to watch surviving edge weapons. Just so it shows how dangerous an assailant can be without a gun, and how justified self-defense is in Kyle's case. Fair. 200 ARS, which anyone's guess is as good as mine. Does that cheap SOB of Rakita share his super chat profits with you and the rest of his invitees, or does he spend it all in booze? I couldn't speak to how he spends it. Beyond that, I'm not going to comment, except to say that Nick is my friend, and I feel valuable to be on his channel. So I won't comment beyond that. $5 for Tim Foreman. Can Binger be in trouble for his conduct? He has some ethical problems potentially, and he's facing dismissal of the charges. So yeah. $4.99 from Austin Bayless. Is it illegal for possessing a gun for a 17-year-old considered criminal activity? And if so, can you claim self-defense while committing a crime? To the second question, yes. Yes, the fact of him being in illegal possession of the gun or not does not impact the self-defense analysis. This is correct. So whether or not he was in illegal possession of the gun does not impact self-defense from a legal posture. And I've said as well, I've seen this in actual felon in possession cases. I've seen people who are convicted felons who use firearms in self-defense, and it doesn't impact their self-defense analysis. It definitely doesn't help when it comes to the felon in possession charge, but for the self-defense charge, it makes no difference. $5 from Kale 777. Congrats on 30K subs. If you cover the upcoming Ghislaine Maxwell, or however we're pronouncing her name, Ghislaine Maxwell case like Rittenhouse, you'll have at least 60K subs up by the end of the year. I don't know that I have the time because I have a day job. I'm actually off for this week, which worked out really well for me because I had travel plans and I didn't know, I thought they might interrupt. So I'm actually off this week, so that worked out really, really well for me in certain timing. But I don't know that I can do that because I actually do have a day job, but we'll see. $4.99 from Tony Omrit. The large set gentleman from defense laughed at the witness's response yesterday. Excuse me. Excuse me. Jet Lane. Excuse me. Large gentleman from the defense laughed at witness's response in a snark and demeaning manner. At what point is that an issue? From the defense? I don't know. I didn't see it. I can't comment on it. $50 from Tall Skinny Geek. Thank you very, very much for this generous super chat. That is very thoughtful. Do you think our prayers for Kyle's work? Sorry if you already answered. I only finished Nick's stream because real life kept interrupting. I think Kyle didn't cause any significant harm to himself. There were no lines that I saw that were particularly detrimental. There was no gotcha moment. There was nothing obvious that Kyle did to ruin his case. That isn't to say he didn't do anything to ruin his case, because the prosecution will now look through his testimony very, very carefully to find anything they can to put words in the defendant's mouth. So I would imagine they're able to extract something. It's just that it's very low value something. I didn't see anything happen in real time. So whatever they're going to be able to find is kind of discount. And they may not use it at all as a result. They might avoid it completely in their closing. So we'll see. But they're definitely going to go over the transcripts. 1999 from Mithrin Emrys. I'm not a fan of Richard's approach of don't let it in and don't object. Yeah. He's been fortunate it's worked out this far, but especially today, he seems to be coming close to not fulfilling his duties. I 100% agree. I 100% agree. Richard's failing to object. There's two kind of conclusions you can draw. This is all part of some master strategy that we are just not able to see, or he's doing it bad. And I've got a stream with 10 lawyers on it, all watching it, and other lawyers who are not on the stream because we can only have 10, and all the lawyers that are in our circles are saying this doesn't make any sense. So either he has managed to get a literal jury of lawyers, like 12 people. He's gotten a literal jury of lawyers who none of us can find the ball. He's that good, or he's dropped the ball. I'm going to go with option drop the ball. $2 from GL. $2 from GL. What is a directed verdict and can apply to this case? A directed verdict is where the judge directs the verdict. He just gives it rather than ask the jury, right? So that's the alternative. You ask the jury for the verdict, and they go deliberate and come back. A directed verdict is where the judge says, here's the verdict. And of course, that can only go one direction. It can only be guilty. Or apologize. Wow, that was a misstep, wasn't it? It can only be not guilty. There's the one I wanted. But yeah, that's what a directed verdict is where the judge says, basically, in so many words, there's no combination of evidence that a reasonable jury could use to convict. So how about not convict? And yes, it can apply at this case. And if the defense is going to make it, it would come either at the end of the defense's case, or I suppose maybe at the end of the, at the end of the rebuttal thing. $2 from James Gentry. Is the prosecution trying to lose this case? It would explain a lot. $5 from Hal Pike. What motivates a prosecutor to go so far as to deliberate mistrial just to win a case? He violates Kyle's rights so deliberately. Does he get money? No, he just gets his salary. So he's not going to get any more money or not for winning or losing. It's a desperate move, I guess. I guess he thinks he has nothing to lose. He has nothing to lose because he's already losing. So if he gets the judge to throw it out, maybe he can spin it politically. It's like, well, it's that mean judge who wouldn't let go of the prosecutor. I was zealously representing our client. And so we can spin it politically. So maybe it's helpful for him in that respect. But he doesn't get any money. He gets paid the same either way. $5 from Patrick. Is it common for a judge to think out loud the way he does during objections? Maybe it's solid, but it seems odd to do it in front of the jury. Most of the time, the jury isn't there. Most of the time when the judge is thinking out loud, the jury isn't there. I think the jury's been there occasionally, but for most of them, they've not been in the room. And yeah, it's very common for a judge to think out loud. I would do that. I think out loud because, yeah, it helps thinking. Blackbird is a member for 11 months. Thank you very, very much for all that. Zao says, can an attorney face palming during testimony be considered prejudice? Well, the only one I saw face palming was the prosecution. So if it's prejudicial, presumably it's prejudicial to them, and when it was their witnesses. So you can't really prejudice yourself. So yeah. Internet commentator said, reminds me of the Julian Benton no and give me a break. Stolen screen name says the prosecutor deserves every black eye he gets. If we apply his reasoning to my life, my going to the grocery store while carrying concealed means I'm going to kill people. True that. 04 Lightning fan says, any chance you'll have Barnes on your channel? Yes, as a matter of fact, I'm working on it. Joseph Cotta says, I'm wondering if the judge is going to dismiss tomorrow. He's absolutely pissed. I don't think I've heard a judge breathe fire like that. Yeah, this is a point of contention I have with Ken White, Mr. Popat himself. Mr. Popat himself was saying judges yell at lawyers all the time, and that's kind of true, but not usually to this degree and usually not to this level of volume. But, me and Popat will just disagree, I guess. Mathur Nanan says, you should see Tucker Carlson's show for tonight. He totally ripped the governor for the way Kyle's been treated by the prosecution. Or maybe it's supposed to be government, but fair enough. $2 for destruction. KR was calling lies. How will that change the outcome? Well, the only lie that I remember him being called out on was where he said to the guy, yeah, I pointed my gun at you when he didn't. And I thought he had a perfectly good explanation for that. So, you can explain away a couple things. And I felt like it was a good explain. So I didn't think it was that big a deal. $200 ARS from Zalorong. You'd be amazed. You'd be an amazing defense attorney because you're constantly playing devil's advocate. Greetings from Argentina. Yeah, I think a good attorney, defense or prosecution, should be playing devil's advocate. They should be figuring out how to beat themselves. This is one of the things you learned, especially in moot court. That's a fun experience. Moot court, the difference between mock trial and moot court is mock trial is typically when it typically means trial, and moot court typically means appeal. So when you do moot court, the nice thing is that you have to write for both sides, because on any given round of the competition, you don't know what side you're going to be on. So you literally have to write both the plaintiff and defendant's briefs. All right. So you are literally just constantly arguing against yourself. And it's a great discipline because you're constantly having to write a brief. You have to write a brief that can't be beat. And then you have to write two briefs, both of which can beat anything and can't be beaten by the other at the same time, right? So you have to write two briefs, both of which can beat anything and can't beat each other. And that's a lot of fun. That's a lot of fun. That will really make you think. And it's a lot of fun when you feel like you've gotten there. It's a lot of fun when you feel like you've gotten there. $5 Sid Lewis says, what's your take on people arguing Binger did nothing wrong with the following case? State versus Weatherspoon. No, that's all right. $5 from John Bryan says, problem is they're potentially waiving objections and not building a record. Yep. Judge is doing it for them. Binger would lose a law school trial ad competition. Sure would. Yeah, the failure of the defense to object means that they lose grounds of objection. They lose grounds to appeal. You can't appeal on something you didn't object for in the first place. Fortunately, they have grounds to appeal on overwhelming way of the evidence, and they've got legal issues with some of the judges' legal rulings. So they have valid issues of appeal. It's just that they're giving up valid issues of appeal. Footage showed Cog claiming Rosenbaum had a gun. Yeah, that too. But again, he was in a panic. So I felt the explanation was satisfactory. So I didn't really feel that was that big a deal. 1999 from Sonny Finwell. If you discuss the Alec Baldwin shooting, which I have in depth, check out John Schneider's YouTube channel. He's been explaining in full how and why the incident should never happen. I hope we talk about the case. I have talked about the case, but I'll check it out. As I said on Twitter recently, I'm just completely overwhelmed with so many cases. There's just too much stuff happening too fast. It's a real issue. Mike Mr. Rowe 13 said, imagine if he had shotgun like he said he initially wanted. Here in a commentator says you have 1577 views right now. I disagree. I have 2182, but thank you for noting it. TTM says, do you think it's weird that after Kyle went through all of his testimony, his legal team didn't acknowledge what a good job did he or even shake his hand? No, I don't think it's actually that weird to not celebrate in public like that, especially in front of the jury. But, you know, yeah. Bass Boy says, with the judge yelling at Binger over constitutional, is a possible grounds for appeal? Yep. Blackbird says, could Binger's boss have given him this turd of a case to sink his political career? It's my understanding Binger wanted it. Jedi Ghost Bear says, it seems like the judge really, really wants a jury verdict, so people have faith in the system, but he also wants to hammer Binger. Can he recommend disciplinary action at the verdict? Yes, he can. But if I were a betting man, I would not bet for him to do that. But, you know, that's just what I think. Propter Hawk says, cheers, brothers. Thank you. Mark Polito says, did the prosecution negate their reckless charge by asking Kyle if he intentionally shot the attackers, with Kyle answering yes? I don't understand the reckless charge. So I don't know how to answer your question because the jury instruction is so weird. $4.99 from Kim Berger. For closing, the prosecution didn't change song. Janie's got a gun to Kyle's got a gun. At least that's funny. $1.99 from Ryan Leary. Zanub says, do you think there was any real logic for the blatant lack of objections, or should defense counsel seek medical aid for narcolepsy? Much more the second, my friend. The legal commentariat is of the collective and apparently unanimous conclusion that the defense doing this doesn't really make any sense, and so I'm certainly inclined to agree with that. Rogue said, congrats on 1.7k viewers. Yeah, now we're up to 22k, or 2.2k. Such a great case for LawTube growth. It's been a wonderful case for growth for sure. $4.99 from Rockstar Adian. Hey Kurt, notice you're watching a cool watch on Rek's panel. Submariner on a NATO? Yes, it is. The Submariner on a NATO. It is exactly that. Good eye. I got it for graduating law school for my parents, which was very nice. Kirby the Kirby said, only subscribe because I've seen you drink yourself to near hospitalization a few times now. Thanks. Stolen screen names. Keep getting on that Rackets daily stream while they're going on. Ride that wave. The more people see you, the more people will be enjoying listening. I'm definitely going to be doing that. I am not a fool, man. Rogue Jen said, is Rescher just lazy for not objecting? I don't know if it's laziness. I just think he's a bad lawyer in this respect. I don't think it's laziness. I just don't think it occurs to him. Because I'm Batman 5702. Gage didn't shoot you, did he? Kyle, in his head. Yes, because I shot him first. Father Core Stitcha. It's been fun watching your coverage as well as the large panel on Nick's channel. Thank you. Taylor Loudenbach said, definitely earned a like from me. What do you think the chances are at this point of not guilty? I'd estimate not guilty and mistrial at 95% at this point. For the major charges. Again, for the reckless endangerment and possession charges, I think guilty is more likely at this point unless the instructions get modified. Ryan Leary says, do you think Richards having to use the bathroom right after Kyle got off had any impact on him objecting? I don't know. Adrian said they were joking. Okay. Internet commentator said, can you put on slow mode? I did that. Mark Polito said, did the prosecution negate the reckless charge? I've answered that question too. I don't understand the reckless charge. Can mistrial with prejudice be granted after the jury returns a verdict? Well, if the jury returns a verdict, you can just do a judgment notwithstanding the verdict, which gets you exactly the same place. Paul F. says, do you think the prosecution would have a much better chance if they admitted self-defense and just went for the recklessness? I don't know. 199 says, what is next? When do you expect a verdict or mistrial? I expect the defense to be, they think they have 3 witnesses left, so they probably will wrap up their case tomorrow with any luck, and the jury will get this case Friday. Seems realistic. And then you'd expect a jury verdict, depending on Friday or Monday. So the law gives 200 ARS. Binginger trying to imply that firing Full Metal Jacket ammo is somehow reckless endangerment because the potential for overpenetration is ridiculous because hollow points in 223 do not exist. Is that true? Hollow points in 223 do not exist? If that's true, then you have some knowledge I don't have. $5 from Joseph Henson. I've seen some people cheering for Maxwell. Maxwell took and found children, led them into a life of work. Cheer the case, not the woman. I don't know why I'd cheer either one, to be quite honest. Any thoughts on the instruction regarding the reckless count? It needs help. Was the motion for dismissal with prejudice actually put forward, or did defense just say they were going to move it? As I understood it, they just said they were going to do it. I don't think it was actually put forward. Brad says there's no such thing as standing. Changed my mind. I'm not going to try because it's a waste of my time. Stephanie says, look at your phone. I did that. Jay said 30K. Thank you very much. We should be known as the Uncivilians. You are known as the Uncivilians. Well, only the members of this channel are known as Uncivilians. Yeah, only members of this channel are known as Uncivilians. For 99 cents, you too can become an Uncivilian. It's true. Hit the join button or the link that comes by from time to time. And Stephanie, while I'm at it, please check my, text messages and stuff. But yeah. Okay, Taylor Loudenbach, we have to have a conversation. When you make the tag, it's caught by my bot. You don't need to ask me the same question 6 times. I saw it the first time. Please stop doing this. Hollow Point 223 does exist and costs more than telling you this. Yeah, I figured it did exist. I mean, that didn't seem right. Now I have to scroll through all the people who asked me the same question multiple times. It's all caught by the bot. I'm doing the best I can. When Nick was talking about a daintily dressed lord, was he referring to legal mindset? I think he was talking about being the prosecutor. I'm going to be in Nick's stream tomorrow, yes. Asking me the same questions over and over and over again, over and over and over again. I feel like I should just ban you from the chat because there's a rule against this. It's really annoying. Swinsker said $5. I was watching the live stream for Kenosha that night. I saw it unfolding live. I remember thinking Rosenbaum was going to be in trouble. Foreign Native says Nick's chat wants you to laugh about it. They're harmless, really. Does Jov have any options for recommending disciplinary? Yes, he does, but I don't think he'll do that. Can defense explain the gun charge in their closing? Yes, but the judge will explain the law after that. They're restructuring the possession charge, so they're not going to redo the reckless endangerment charge. So if they're not going to redo the reckless endangerment charge, then you'd predict for a guilty verdict for reckless endangerment, which incidentally is a maximum of 12 years, 6 months in prison, in case you wanted to know. Taylor Loudenbach says, is it illegal for someone under 18 to possess a rifle? So how can you be found guilty of possession? That's the judge's ruling. What do you want from me? The judge is the one who says what the law is, and that's... Lightning Fan says, you think the jury will follow the law? I don't think I said I think they would. I said if they did. Taylor Loudenbach continues to annoy the shit out of me for some reason. Trevor says, on a scale of 1 to Jesus Lord why, how much do you think the jury hated why don't you render aid to the people trying to kill you, and he had a smaller gun arguments? They're pretty bad. All right, I'm not answering any more questions from the bot because you guys can't control yourselves. I cannot keep up with them being asked the same questions over and over and over and over and over. All right, so we're not going to do any more of that. Anyways, thank you very much for everyone being here today. So, yeah, Stephanie, give me a call after the stream is over. Thank you for being here today during the stream. I really appreciate the 2,000 of you who are here, 2,200 of you are here. We'll continue doing the objection streamers combative with chat. Relax. Okay. I mean, I don't know why, but this is not the first time I've seen this comment. I am not allowed to be mad at the chat. Okay. I'm sorry. I'm sorry for having an opinion. I was wrong. If you're enjoying this stream, please remember to like it. If you're not subscribed already, please remember to subscribe. And did you know for near 99 cents, you too can be on an Uncivilian? It's true. If you just hit the join button or hit the link the Streamlabs is telling you about from 99 cents, it will help you. It'll help the channel grow. I appreciate everyone who's here as a member. I hope all of you have a wonderful night. Until later, my friends. Hope all is well. Cheers and goodbye.